Are we all set? The 2AC frames the division of ontological boundaries the biggest impact of the round state leads to systemic violence. You can see a couple of arguments. First, you can see the Harrison 2002 evidence read in the 1AC. This evidence is damning. They have zero evidence in the 1AC or the 2AC. This is the privileges or immunities clause does not only apply to citizens. We read specific evidence that talks about the legal interpretation of the courts, which means that even if they win an internal link argument, that they can somehow cause a reinterpretation. This is irrelevant because common jurisprudence means that the court will mandate that it only applies to the notion of citizen versus non-citizen. This is internally to all their Derrida arguments. Their evidence indicates you must have an unconditional acceptance of the stranger in the notion of community, but they can see the Berkeley 2002 negative alternative solvency evidence says that we will articulate new ontological boundaries that exclude people like the refugee, people that are traditionally considered non-citizens. This is also articulated on the case debate in which we chose that the history of the privileges or immunities clause is one that was allowed to uphold the notion of racist laws. The plaintiffs does not do anything close to what the solvency advocates want. She says that we have to ground a rights education in the 14th Amendment. This was our reevaluation of segregation does not reverse causal. The reevaluating segregation would reject the right to education. If the act is not right into rights to education, the inerrancy proves the plan will be interpreted. The evidence goes on to say locating the right to education in the 14th Amendment might inspire litigants in courts together to revise 14th Amendment doctrine to reinforce adoption substance transformative potential. None of the Andrews evidence says that the privileges and immunities legally apply to citizens and non-citizens, which means they have to win a massive risk of a spillover, especially in a world in which they concede the Zartalidis rights-based argument that says whenever you allow the court to create the boundaries for who does and does not have rights, it gives them granted sovereign power that allows them to exclude notions of citizenship. This is the internal link to their argument about internal violence, and a positive rights reading of privileges and immunities clause incorporates the central task of dividing rights between citizens and non-citizens, meaning we're still the only team reading evidence on this point. Harrison 92. Two constitutional provisions speak privileges and immunities. Citizens approach 14th Amendment asserts the central structure privileges and immunities is variable. This is given by value of the concept relative to law. Neither Article 4 nor the 14th Amendment does the concept have any independent content of its own. The last observation points to additional attraction from the clause of law. Understanding of privileges and immunities advantages most of the baffling uncertainty that still surrounded the words of the students of the 14th Amendment. The concept is indeed the central task is distinguishing between those aspects of the positive law that constitute citizen rights and those that do not. The task is not easy, but it's not difficult as inquiry into natural rights. They have zero evidence to answer this argument. They can see the internal link impact evidence from the 1C. This is not only historically has been used to create boundaries, but it also is an internal link to the only affirmative advantage. The only impact right in the 2AC is the notion of racism or an exclusion, be it based on ontological boundaries. We're beating not on the notion of the way they necessitate the law, but also in the context of our alternative. They have conceded that the Burke evidence is the demand that their GJAC evidence talk to. It's a modest demand because it requires us to reconceptualize law through the concept of the refugee instead of the citizen. Our evidence says this is the only way we can have a fully inclusive community, which is the only way the affirmative claims to solve racism in the status quo, because it forces us to re-examine what human rights is. They've also conceded the most important internal link argument that because the most basic example of the state of exception is the application of human dignity to only citizens, it writes an exception into the cause of humanity. Jenkins, 2004. The key point I wish you would take from Gommon's analysis, the thought where certain injustice and forms of violence in the contemporary world are not being perhaps not being resolved in the currently prevailing juridical political frames. The case of refugees is difficult to approach with an interpretation of rights that effectively upholds and enforces the rights of citizens who is eligible for the universal inclusiveness of merely human rights already constitute an exception to the norm. And they have no offense on this flow. All of their arguments are we can try to create a community, which means they've conceded the alternative is functionally a better way because we demand that those rights start with the figure of the refugee, which means there's always a solvency deficit between the affirmative and the alternative. They read this novel in 86 evidence, say they hold the law accountable. This is not an offensive argument for the AF. Even if they win 100% of this evidence, it means they only hold the law accountable for people that are deemed citizens under the privileges or immunity clause. There's nothing else in the plan text outside of that clause of the Constitution, which means they have no argument as to why the court would be forced to reinterpret it to include things like immigrants and refugees. This is also a logical argument. Do you honestly think the Supreme Court would expand this decision post the plan in order to allow it to have immigrants and illegal aliens in the country to also have a fundamental right to education? That makes no sense. Their Derrida evidence says that kind of exclusion is what necessitates violence towards the being of other. He says himself in the 2AC that it is a structural impact that you must value above all others, meaning that even if they win some form of dissent in the world of the alternative, we always win, that the biggest impact of the round is solved better in the world of the negative critique. They read this evidence as laws need to stop hierarchies of race, power, and gender. This argument is not offense. They have no arguments why the negative alternative is mutually exclusive with law. Our alternative Burke in 2002 evidence does not say that we should reject the law as a violent manifestation in all instances. It says that what we should reject is framing the law in linguistic coordinates that require people to be citizens of a nation state until they are subjected to the rights that all humans can have, i.e. it is the idea that we've created a law that says that if you are not a citizen, therefore you do not fulfill the category of human and do not have rights devolved for you. The Harrison evidence I read above is damning as to how this is the way that the privileges and immunities clause interpreted. It even says that the job of the courts is to distinguish who is a citizen and is a non-citizen, and therefore who is able to have have rights. This is our rights giver link argument read in the 1C that they did not answer. They can see this internal link to not only our xenophobic racism impact, which I believe was from a South Asian king, which is a pretty good qualification, but also our Burke in 2002 evidence says that this is not only the root cause of racism, but it is what allows us to ontologically exclude people and subject them to things like genocide, torture, because we dehumanize them in the first instance, and then we write them out of the category of being legally human. And legal decisions that extend basic rights to underrepresented groups fail to stop biopolitical control of humans through the law. Their decisions are still grounded in the linguistic terms and strategies of the legal system. Negri in 2005. Some of the individual instances of resistance can still produce general effects of sabotaging the system, gestures and tactics refusals to open up to alternative strategies. None of this was realized, at least not in any visible way. Even the restorative decisions, the court's not only tribe mechanisms set in motion by democratic legal proceedings were neutralized and the constituent powers of freedom suffocated. The fact that matters, the more new technologies of governance become effective in managing, particularly leading back into a system of command, the more one witness the onset of multiplicity of violent shifts, more or less capable of clearly being articulated and producing subjectivity, yet always proliferating. Substantive interests and subjective rights would not have had the space to develop and mature outside these interstitial dispositives. None of this is enough. The insistence of legal strategy on the intersystem, no matter how open the speed of proliferating tensions, cannot establish a new juridical horizon. Inventory moments are drawn into the abyss of the structures of command, at which point there is once more the void. This is a devastating argument in the context of our Burke in 2002 evidence, because it proves that anytime you give the court an excuse to ground things in the linguistic notion of the citizen versus the non-citizen, or the rights bearer versus the rights giver, it allows them to functionally exclude people, which again is the only impact of the one you see. They read this Andrews in 2004 evidence says they can solve communities. This is about how we can reformulate our intersubjectivity and notion of the people around us, i.e. kids in desegregated schools will somehow look at people of a different race differently, but this is irrelevant. This is not an answer to our criticism. Our criticism is not about the way that I view you and you view me. It is about the way that the law has formulated itself around the notion of the human and what constitutes the human, meaning that even if they win this community impact, it's not enough to outweigh the impacts that I've articulated above, especially since our links internally turn the affirmative. They read this Valley in 2004 evidence to say that rights are good and that Agamben throws the baby out with the bathwater. First of all, this is not a standard Agamben criticism. Our Burke in 2002 evidence is about why human rights law has the potential to be emancipatory and valuable to people, which means we're not mutually exclusive with rights. We are literally only saying that rights that require a notion of citizenship in and of itself are bad forms of rights, which means they cannot win any offense off of this Daly in 2004 evidence. We will also, we will win that their praxis is violence. Failure to rethink the notion of sovereignty in terms of the human means your praxis will continue to be ensnared in biopolitics and its violence. Change must come with the alternative. Agamben 98. This task has led more and more to a stream from a form of biopolitics. Western politics is not succeeding in constructing the link between voice and language that would have held the fracture. Real life remains included in the politics in the form of the exception. That is something that is included solely through an exclusion. How is it possible to politicize the natural sweetness of Zoe? Modern totalitarianism, the society of mass hedonism and consumers certainly constitute answers until a completely new politics no longer founded on the exception of bare life is at hand. Every theory and every practice remain imprisoned and immobile in the beautiful day of life will be given citizenship only through blood and death, or in the perfect sense to which society of the spectacle condemns it. This evidence is also very good about showing the necessity in the world of the alternative. They've also conceded our Burke evidence says it's not a radical alternative in the sense that we would have to crash the system. It literally just requires us to rethink the way that we originally conceptualized that system, which is why we don't reject the notion of law in and of itself. We only reject the notion of law that allows sovereign power to dictate who does and does not have rights. The alternative would always be net beneficial in this instance because it allows a truly wholesome and an inclusive community, just like they claimed us to do with 1AC. The last piece of evidence you read is Rose in 2003 evidence that says using biopower politics can be good in order to stop it. Cross-apply all the impact arguments I made above. They've conceded the argument that the biopolitics we are talking about is one that allows ontological boundaries to be created. The 2AC waxes poetic is about why this is the most important atrocity that must be stopped in the planet right now, because it allows the perpetuation of structural and racist violence, which means that even if they win using some forms of biopower are good, this is irrelevant because we are saying that they use the form of biopower that they indict inside of the 1AC, which means it's not an offensive argument. And our alternative is not asked to sit idly by and wait for a new community and entails an already political struggle for ethical happiness away from sovereign power. This is the opposite of the theological mysticism your evidence assumes. This not only answers the Rose evidence, this is also an answer to the G-Jack evidence. McGill in 2005. Agamben will not need to reach any kind of mysticism, so absolution concerns not only thinking, also living. Philosophy is always already political for Agamben. Agamben takes Heidegger further than this point he himself was willing to go, and this is why Agamben disagrees with Heidegger on one crucial regard, where Heidegger says the polis is the site of the most extreme conflicts. Agamben claims that there is a form of life for which power has no hold. Politics, Mr. Life drawn from decision and sovereignty can survive, though obscured by the absolute political space of the camps. The fractal life of Desainus, the inseparable unity of being and ways of being subject and qualities life in a world in which it is never possible to isolate bare life and existence or form life for which power no longer seems to have any hold. This opens the door to a different politics.
I get the 1AC alternative and then the alternative cards you read in the
You can have the 1NC alternative after the 1NR.
I can give you all the cards I read in 2NC. I didn't really read any more alt solves stuff.
Well, then just that last one, I guess. All of our evidence indicates that inclusive humanity is impossible, while the Millikan decision is as it is in the way that it interacts with law. How does your alternative overcome this?
Well, the only point of contention between the two teams at this point seems to be that we feel the Privileges or Immunities Clause only applies to citizens, and you feel it doesn't. So I guess we overcome
But that's
it
not my
by
question. How do you
including
stop
non-citizens.
How do you stop?
Wait, hold on. The alternative would overrule Milliken by
I didn't
also
say
include
that.
non-citizens?
I said the alternative would require the law, all human rights law to include non-citizens.
How?
That's what our text and cards say. The
My goodness.
alternative.
Is it the idea that we should believe that, or do you actually change
You want it for
jurisprudence?
cross-section?
Our argument is from the 1 and C was, as I said in cross-examination, Wizards voting for the alt text, which is we should reformulate human rights based around this instead of that.
Okay, so my question is, what would your alternative do to Milliken?
The Milliken decision specifically,
What
or
would it do to the way that it interacts with?
I don't want to say the Milliken decision, but the Privileges and Immunities Clause would certainly either be struck down or at the very least expanded to include citizens and non-citizens. In theory, I can't tell you whether the Constitution would look like in every aspect post the world of the alternative, but in terms of human rights
your
law,
alternative,
which
your
is what our
alternative
critique
has
is.
The Supreme Court changed.
No, you're not listening to me. I'm saying in the world of the alternative, Privileges and Immunities Clause would not be allowed to distinguish between citizens and
I'm just wondering
non-citizens.
how you go about doing that. Do you actually use the Supreme Court to reform jurisprudence, or is this
No.
something that we just believe should happen?
Yes, sure. I mean, are you asking framework questions? Because that's going
It's
to be
not entirely a
the
framework question, it's more of a solvency question of your
It's
alternative.
like, at the end of the round, Wizard has to make an intellectual judgment over what arguments were more valid, okay?
Yeah.
We feel that at the end of the round, he should sign negative because we have critiqued your concept of human rights and we have presented one that intellectually
Okay,
is
all
more
of our
vigorous
evidence discusses
and accepting.
humanity, not humans, not humanity of the United States. Even if our plan text doesn't discuss
No,
the distinction between
all of
citizens and
the
non-citizens,
cards we're reading about privileges
besides
or
our plan
immunities
text?
clause are certainly specific to people
Our
in the
evidence
United
indicates
States.
that even though the privileges and immunities clause is about citizens, that we would reform
Your
the way
evidence,
that
that's what's so
citizens
funny,
work
is
to include
he's
non-citizens.
going to read your evidence and you're going to be totally exposed as a
Okay,
liar
so when our-
because
when
your
our
evidence doesn't say that.
humanity
And I even
is
read it
a goal,
4
it's
extra
about
times because I thought maybe you weren't bullshitting me in cross-X.
So when our evidence indicates humanity, it's only talking about citizens?
Your
I don't
evidence,
understand.
no, the thing that I'm saying is your evidence does not speak to the fact that the privileges or immunities only applies to citizens. It
That
doesn't
seems
even acknowledge
irrelevant
that.
to what our plan
Therefore,
does after using the privileges and immunities clause.
Then we would default, assuming you can win that argument wholeheartedly, we would default to my 2 and C argument that there's still a solvency deficit because you're at least
So you have
allowed
a
to read.
solvency deficit. All right.
That's my 5th fallback argument if you win all your other ones.